right. Hello, everyone. I'm Steve Bergstein, and I am a civil rights lawyer. I live in New Paltz, and I practice law in New Paltz, and I will speak this evening about the recent Supreme Court case that protects the rights of gay and lesbian and transgender employees from discrimination in the workplace. And I worked on this case, as June said. I will talk about what the Supreme Court did, how the case got there, and my personal observations from the experience. On June 15, 2020, about a month ago, the Supreme Court ruled by a 6-3 vote that the federal employment discrimination law makes it illegal to discriminate against people because of their sexual orientation. And that case is called Bostock versus Clayton County. But Bostock was actually 3 cases from around the country that the court consolidated for purposes of oral argument and decision, including a case from New York. That case was called Zarda versus Altitude Express. And Zarda is the case that I worked on. I've been working on Zarda since 2016. I didn't file the case, but I joined the case once it reached the appellate level, and I participated in the strategy discussions for the Supreme Court phase of the case. So in short, before I get into the details, let me just give you an overview of what the Supreme Court did so you understand the context. What the Supreme Court said in Bostock was that sex orientation discrimination is a form of gender discrimination, and gender discrimination is prohibited under the federal employment discrimination law that we know as Title VII of the Civil Rights Act of 1964. So what made this ruling significant is that the Civil Rights Act of 1964 says nothing about sex orientation discrimination. That language is simply not in the statute. What the Supreme Court did was not add language to that statute. They don't have authority to do that. Only Congress can do that. What the court said was this kind of discrimination qualifies as gender discrimination in violation of the Civil Rights Act. So Congress doesn't have to amend the statute. And I'll discuss later on, there have been efforts over the years to do just that. Those efforts are no longer necessary because the Supreme Court said it's really a form of gender discrimination. So let me give you some background. The Civil Rights Act of 1964 was probably the most far-reaching statute Congress ever passed. It covered discrimination in just about every aspect of American life, including public accommodations, education, and the workplace. And since everybody works, this law truly affected just about everybody. But the Civil Rights Act of 1964 only prohibits discrimination on 5 grounds: race, color, national origin, religion, and gender. And that hasn't changed in the last 56 years. 3 years later, Congress passed a separate act making age discrimination illegal. And in 1990, Congress said disability discrimination is illegal. But the Civil Rights Act has not been amended in terms of who is protected under the statute. And the court rarely gets bogged down into what constitutes race discrimination or religious discrimination or even gender discrimination. This is one of the first cases where the Supreme Court had to actually define what constitutes gender discrimination under the statute. And, probably in 1964, they probably thought this was a clear issue. They didn't have to really explain it any further. But, times change and legal minds change and the Supreme Court changes, and here we are. So let me give you a brief history of gay rights in the Supreme Court. It's a relatively short discussion. It's safe to say that in 1964, nobody was thinking about sex orientation discrimination when the Civil Rights Act was passed. To the congressmen and women who passed the law and to President Johnson who signed it into law, gender meant women. And it was only 5 years, it was 5 years before the Stonewall riots in New York City, which happened in 1969. And many of us know Stonewall was probably really the beginning of the gay rights movement. It took many years and several decades before gays and lesbians had any rights at all. Stonewall was simply an uprising, but it didn't change the law at all. So in 1986, the Supreme Court took up its first gay rights case, and I don't believe everybody on the Supreme Court in 1986 is no longer there. They have all since retired. It was a very different court. And what the Supreme Court ruled, this was Bowers versus Hardwick. Some of you may have heard of this case. It became notorious. The Supreme Court said that sexual activity among same-sex couples is not protected under the US Constitution, even though the court said in 1972 that those those rights are extended to unmarried couples. So you had a clear distinction being drawn by the Supreme Court, where same-sex couples lost that case. That was a 6-3 decision. And there's an interesting little anecdote that accompanies that case, which gives you a sense of what was really going on at the court at the time. One of the justices who ruled against the plaintiff in Bowers was Justice Lewis Powell, who was considered the swing vote on the Supreme Court. He was appointed to the court by Richard Nixon, but he sometimes voted with the liberal side of things, depending on the issue. Justice Powell is probably the reason we have affirmative action in this country today. But at the time of Bowers, he was talking to one of his law clerks, and those are the people who work for the justices and help them do research and help them write their opinions. They're brilliant law school graduates. Justice Powell said to one of his clerks, he goes, I don't think I've ever even met a gay person in my life. And in fact, the very law clerk that Justice Powell was talking to was gay. And those were the days when you probably didn't tell everybody if you were working at the Supreme Court about your sex orientation. So that was a big loss for gay and lesbian plaintiffs. 10 years later, things changed. A case called Romer versus Evans out of Colorado. Supreme Court ruled that Colorado could not amend the state constitution for purposes of preventing civil rights protections for gays and lesbians. And this was a voter-initiated constitutional amendment in Colorado. It was sort of a backlash to some of the same-sex marriage decisions of the early 90s from, I think, Hawaii and Massachusetts. And the voters of Colorado said, you cannot change the law to protect gays and lesbians. I know it sounds crazy, but that's what they did. And the Supreme Court in 1996 says you cannot change the law to disadvantage a class of people simply because you don't like them. And the justice who wrote that opinion surprised everyone. It was Justice Kennedy, appointed at the Supreme Court in 1988 by Ronald Reagan. Justice Kennedy, no relation to the Kennedy family of Massachusetts, was considered very conservative, but for some reason, he is the justice who always cast the deciding vote in front of gay and lesbian plaintiffs when he was on the Supreme Court. And in 2003, he wrote the opinion in Lawrence versus Texas, which overturned Bowers versus Hardwick. So Lawrence versus Texas says same-sex activity among same-sex couples is protected under the Constitution. That was Justice Kennedy. And then, as we all remember, in 2015, the Obergefell case, recognizing the right to same-sex marriages under the Constitution. That was Justice Kennedy. Also, these were all split decisions. They were not unanimous. They were either 5-4 or 6-3. And when Justice Kennedy retired in 2018, civil rights advocates were worried because they didn't know if his replacement would be as sympathetic to gay rights as Justice Kennedy was. And we knew this would have consequences for the case that I'm talking about today, because the case Bostock and Zarda and also Stevens, that's the third case from the Bostock trilogy, those cases were winding their way through the federal court system. And we knew there was a good chance they would end up before the Supreme Court. And we didn't know what would happen when Justice Kennedy got on the court. And that replacement, as we remember from 2 years ago, was Justice Kavanaugh. And this is the life of a civil rights lawyer, where the law changes over time and you worry about who's on the court and who's making decisions and whether they're going to agree with you or not. So meanwhile, the Zarda case is going on. But for many years, enterprising lawyers had tried to convince the federal courts that sex orientation discrimination was somehow a violation of Title VII and that it was a form of gender discrimination. This had been going on since probably at least maybe the 1970s or the 1980s. And every court that took up this issue said, no, sex orientation is separate from gender. You lose. And the courts often didn't even have extended discussion on this issue. They simply said that they're separate and apart. If you don't like it, the next train to Washington leaves in 20 minutes. You can lobby your congressman for this, but don't look to the courts to change the law. And as we all know from civics class, the court is supposed to interpret the law and not make the law. And so I think every federal jurisdiction in the country up until 2015 or so took the view that sex orientation discrimination was legal under federal law. And if you didn't live in a state that made it illegal, like New York, you had no rights at all. And so most states did not protect people from this form of discrimination. And every civil rights lawyer will tell you stories of people calling you on the phone saying, I just got fired, I want to bring a lawsuit. And you say, you can't bring a lawsuit because you're not protected, either because most employment decisions are presumed legal unless you can somehow fit it into Title VII, or in the case of sex orientation discrimination, the law is not there for you. And those could be very unpleasant conversations, but you're a counselor at law, you have to tell people what the law is. So things changed in 2015. In 2015, we have a federal agency called Equal Opportunity Employment Commission. If you've ever worked in human resources, you know about the EEOC. That is the federal agency that was created by the 1964 Civil Rights Act. And that is the agency that is responsible for interpreting and applying the provisions of that law. And if you want to bring a lawsuit, you have to first go through the EEOC and give them a chance to investigate and try to settle the case. And in 2015, the EEOC took a fresh look at this issue, and they decided that sex orientation discrimination is a violation of Title VII, and it was called the Baldwin decision. And this was big news for people who did this work. And they obviously gave this a lot of thought because it was a very lengthy 10-page single-space discussion that was thorough and well thought out. And here was the logic behind what the EEOC said in Baldwin. First, firing a man because he's attracted to men or in a relationship to men discriminates on the basis of gender, because women are not fired when they're attracted to men or when they're in relationships with men. So the critical distinction in these scenarios is gender. So if Frank is fired for dating Harry, he would not have been fired if Frank were a woman instead. And what the EEOC said was the decision to fire somebody because of their sex orientation is inherently gender related, because you have to take somebody's gender into account in making this employment decision. And that's pretty creative thinking, but it's logical. And the EEOC had two other reasons why sex orientation is a violation of the gender discrimination provisions. First, you're engaging in stereotypes. And the courts have held for years that if you make decisions based on stereotypes, you're violating the civil rights law. So there's a famous case involving Price Waterhouse where a female accountant was denied partnership because she was too masculine. That's what they said. And the Supreme Court said, that's stereotyping and that's illegal, and Title VII prohibits it. So the EEOC applied that logic to employment discrimination based on sex orientation. And the third reason the EEOC arrived at this conclusion was what we call associational discrimination. You cannot fire somebody because of who you associate with. For example, there was a well-known case in New York where a guy was fired because he was engaged to be married to a Black woman. And that was associational discrimination. And the EEOC applied that logic to same-sex discrimination as well. So it was a victory for plaintiffs, but the EEOC rulings are not binding on the federal courts. They're sort of advisory, and a federal judge doesn't have to follow the EEOC's guidance if they don't want to. And eventually, the Zarda case, as I mentioned, was winding through the court system. At this time, we were using the logic in Baldwin to win Zarda. And let me give you some of the facts of Zarda. Zarda was a skydiving instructor on Long Island who was fired for telling a customer that he was gay, and he did this as a means to ease her nerves about skydiving. Now, I've never been a skydiver, but I would imagine that if you're a customer and you have to do it in tandem with a trained professional, they strap themselves to you. So you're really like one person for purposes of the skydive. And most people, when they're about to jump out of the airplane, are pretty nervous, and the skydiving instructor has to put them at ease, and they do so with humor. And so this was a female customer. He straps himself to her, so they're very tight at the moment, and he makes a joke, "Don't worry, I'm gay." And this is the way people talk to skydiving instructors. Male heterosexual instructors would talk about their sex orientation at work. Also, they talk about their families. But Zarda was fired for that conversation, even though comparable men who were not gay were not fired, even though they talked about their heterosexual relationships. So this was a good test case for challenging the longstanding interpretation of Title VII that the courts had adhered to for so long, including the court in New York. The Federal Court of Appeals in New York in the year 2000 said that Title VII doesn't prohibit sex orientation. That was the Simonton case. An enterprising lawyer in New York City by the name of Greg Antolino, he took the Zarda case, aware that the Simonton case from 2000 was still good law, but sometimes lawyers have to do this. And the storybooks are legion. There are stories of lawyers who take chances all the time, even though the law is against them. They do it because it's the right thing. Think of Thurgood Marshall bringing his race discrimination cases in the 1940s and 1950s. He almost got killed doing so. Somebody has to bring these cases. And so the Zarda case was brought as a means to change the law in this area, which the legal system allows you to do, but the trial court said no. You know, the initial court where Zarda brought his case said, no, you can't bring this case. The law is against you. The precedents are against you. If you don't like it, go to the Court of Appeals. And that's when I entered the Zarda case. So in February 2018, the Federal Court of Appeals in Manhattan reversed its prior precedent on this issue and ruled by a 10-3 vote that Title VII makes it illegal to discriminate on the basis of sex orientation, primarily adopting the logic that the EEOC had advanced in 2015, that when you fire somebody because of their sex orientation, it's inherently a gender-based decision, and there's also stereotyping involved and associational discrimination. This was only the second time that a federal appeals court had ruled this way. A federal appeals court in Chicago a year earlier did the same thing. The problem was you had other federal courts around the country which came out against the plaintiffs and held to the longstanding view that Title VII didn't protect people on the basis of their sex orientation. And so that tees up the case for the Supreme Court. Just as a side note, you know, there's always funny little war stories that come with all these cases. When the case went to the Court of Appeals, when Zarda was argued in the Court of Appeals, the EEOC argued on our side because they agreed with our position. But the Justice Department was arguing against us. This was the Trump Justice Department. So you had the federal government arguing against itself in the same case, which I've never seen before, but theoretically it's allowed to happen. One of the judges on the Court of Appeals asked the Justice Department lawyer, just out of curiosity, how did this happen? You know, what deliberations led to this situation where you're arguing against a federal agency on the same legal issue? And the lawyer got a little uncomfortable with that question because he didn't anticipate it probably. And he simply said, I am not at liberty to divulge internal deliberations, but it was a rare light moment, and everybody laughed. And it was a rare light moment during an otherwise very intense oral argument in the case. So as I mentioned, you know, we won in the Court of Appeals 10-3, but there was there was some concern with the dissenting opinion. The judge who disagreed with us wrote a lengthy dissenting opinion, Judge Gerald Lynch, maybe 50, 60-page discussion why we were wrong. And he agreed with us politically. He said that he wishes Congress would amend the law to prohibit sex orientation discrimination, that he agreed that it should be illegal as a moral matter, that people shouldn't be allowed to get away with this, but he didn't think it was the role of the courts to make this decision because in 1964, when the Civil Rights Act was passed, nobody thought that it might be extended to include sex orientation discrimination. Now, so Judge Lynch was a Bill Clinton appointee to the Court of Appeals. His resume is to die for. He's brilliant, and that gave us some concern that if he writes an extensive and scholarly and thoughtful dissenting opinion that goes on 60 pages, if we ever lose this case in the Supreme Court, it's going to be because of Judge Lynch's dissent. And so the lesson from that is you can't always pigeonhole judges based on your case. You know, you assume somebody's going to be on your side, they're not always on your side. Fortunately, it was 10-3, so for the moment we won. But we knew this was going to go to the Supreme Court. And when Zarda was decided, it was front page news and it was a national story. But since that case reached a different result from other cases around the country, that's when the Supreme Court gets involved. And let me explain a little bit about how the Supreme Court works. They only hear about 60 to 70 cases a year. Some of them become big news, like the cases we had last week on the Trump subpoenas. A good deal of what the Supreme Court does, the public doesn't really care about because they involve interpretation of federal statutes or bankruptcy code or provisions of the Constitution that don't get all the attention that, say, the First Amendment gets, but still 65 to 70 cases a year. The Supreme Court, you have to ask the Supreme Court to take your case. They don't take it on their own. You have to file a petition. It is estimated that about 7,000 petitions arrive at the Supreme Court every year from lawyers who are desperate to get the Supreme Court to hear their case. And, hope springs eternal when you file a petition with the Supreme Court. It's called a certiorari petition. They're expensive to bring, they're time consuming to write, and it probably takes the justices, their law clerks, no more than 10 minutes to read, if that. So most cases that go to the Supreme Court are never heard by the Supreme Court. They only take cases that are either of monumental importance or cases where the lower courts can't seem to agree on the same legal issue, and the Supreme Court has to be the final decision maker on how some federal statute is going to be interpreted in light of, a particular factual situation. What that means is that technically, there is no such thing as really a frivolous legal issue that reaches the Supreme Court, because the case reaches the Supreme Court primarily because intelligent and highly qualified judges around the country can't agree on a particular legal issue. And you could have really thorough, comprehensive decisions around the country on the same issue. And if they don't agree, well, you assume that, most legal issues before the Supreme Court have two plausible legal arguments for and against. Even if you don't like the result, there usually is a basis to vote one way or the other. And the issue that we're talking about today, sex orientation discrimination, certainly qualifies as a non-frivolous dispute where both sides have arguments, as evidenced by the fact that the federal courts over the last 25 years were unable to agree on this issue. So the Supreme Court grants the petition of the losing side in all these cases to hear the case. And it's like, oh my God, we're going to the Supreme Court. And most lawyers have never really seen the inside of the Supreme Court. The Supreme Court does not televise its arguments. So the most we can get out of the Supreme Court is a transcript of the oral argument, which comes out later in the day. And even that's a recent development. So the Supreme Court is sort of a very mysterious public institution that they don't really look for publicity. And unless you're a Supreme Court junkie and you do this work for a living, most people really know very little about who's on the court. And so just as background, right now on the court, you have 9 justices. 5 of them were appointed by Republicans. 4 of them were appointed by Democrats. And each of the justices seem to vote in a manner that is consistent with the ideology of the presidents who appointed them. So that the 5 conservative justices who were all appointed by Republicans and the 4 liberal justices were appointed by the Democrats. That was not always the case. In the past, we had some very conservative justices who were appointed by Democrats, and we had some very liberal justices who were appointed by Republicans. So Earl Warren, some of you may remember Earl Warren, Chief Justice, he's the one who desegregated the schools, was appointed to the Supreme Court by a Republican President Eisenhower. And then Harry Blackmun, who was the chief proponent of abortion rights in the Supreme Court throughout his tenure on the Supreme Court, he was appointed by Richard Nixon. And nobody really predicted what these guys would do, but now it's a little more predictable. Supreme Court nominations now are much more contentious and they get emotional. And I mentioned Justice Kennedy a little earlier. He was the 3rd choice when Justice Powell resigned in 1987. The first choice was Robert Bork. And you probably remember Robert Bork if you were around during that time. Robert Bork's nomination was rejected by the Supreme Court because the Senate thought he was too conservative. And then the next nominee crashed and burned. And then they went with Justice Kennedy. And by then everybody was fatigued and he got appointed to the court nearly unanimously. So that's the situation heading into the Supreme Court. We knew that there were 5 conservative justices and we probably wouldn't get all of their votes. And we were worried because Justice Kennedy wasn't there anymore. And how is his replacement going to rule on this issue? What is Justice Kavanaugh going to do? And there was another new justice on the court also, Neil Gorsuch, also appointed by Trump. He got there in 2017. So far as we knew, they hadn't ever expressed an opinion either publicly or in the course of their prior judicial service on this very issue. So we didn't know what was going to happen. But we had no choice. The Supreme Court takes the case. We have to proceed with the case. So the question before the court was a very simple one. Is sex orientation and transgender discrimination a form of gender discrimination? That's a legal question. You know, when this issue got to the court and it got a lot of press coverage and people began protesting on the issue, I think for many people, the issue became a moral one. You know, oh my God, the Supreme Court is going to decide whether, you know, you should be able to fire people because they're gay. That's sort of the issue, but that's not the precise legal question. The Supreme Court is not there to make moral judgments, at least they're not supposed to. That's Congress's job. So we had to fit our legal arguments within the existing legal framework that applies to these cases. And our best argument, as we strategized about this and talked about what to do and began working on the briefs, was, as I mentioned earlier, sex orientation and transgender discrimination is a form of gender discrimination because it's necessarily taking into account gender, because you have to consider somebody's gender in determining whether his or her romantic choices are acceptable to the employer. The other theories that I mentioned earlier from the EEOC, associational discrimination and stereotyping, those were dropped as we proceeded in the Supreme Court. Our brief only focused on the main issue of necessarily taking gender into account when you make a personnel decision based on sex orientation. That was sort of a strategy question. The employer, you know, their best argument was that in 1964, no one contemplated that sex orientation would be covered under gender discrimination. And probably if somebody mentioned it as a possibility, it would have been voted down because there were no gay rights in 1964. I don't even think it was on the radar. To give you an example, sex harassment was rampant during the 1960s. And if you ever watch Mad Men, you can see that. And in 1986, the Supreme Court said that may be true, but it still qualifies as gender discrimination, even if Congress hadn't taken it into account when it passed the Civil Rights Act. So that was an argument in our favor, that even though sex orientation was not, you know, on the radar in 1964, you take the law where you find it, you apply the law as it's written, and you don't worry too much about what they had in mind when they passed it. You simply determine whether the language of the law, what people call the statutory text, of whether the language of the law prohibits it or not. And the sexual harassment argument was there for us as an example. Another example of this is that in 1964, I seriously doubt there was much thought given to discrimination against men. But over the years, the courts, including the Supreme Court, said that men can sue under Title VII also if they're discriminated against because they're men. So that was an argument for us. But the argument for the employers was, you know, that's all very nice and that's all very interesting, but sex orientation is not gender. It's too far afield from gender. And you have to consider that over the years, people tried to amend the statute to include sex orientation discrimination. It never worked. There was never any will. The political will wasn't there. That's got to count for something. That is not a frivolous argument. There's arguments against it, but as I mentioned, in the Supreme Court, nothing is ever really frivolous. So the case is teed up for the Supreme Court. The next decision you have to make is who's going to argue the appeal, right? Now, in the old days, back when the Supreme Court heard 150 cases a year back during the 70s and 80s, if you brought the lawsuits, you know, in Wichita, Kansas, or New Paltz, New York, or wherever you happen to be as a lawyer, you were probably the person who was going to argue the appeal. So it might be your only trip to Washington in your life, but there you are arguing before the Supreme Court. That has changed. The latest trend in Supreme Court litigation is that you have a specialist argue the case. You find somebody who's argued and won before, who knows the court. Maybe they used to work for the court as law clerks. Very often, these individuals are going to be law professors. This is all they do. It's all they think about. They can prepare for the oral argument a month in advance, whereas everyday lawyers only have a week to prepare. And there are now lawyers who have argued 50 cases in the Supreme Court because that's all they do, and they know everything, and they know it the way a law professor is supposed to know it. And they certainly know it better than an everyday practitioner, even if that everyday practitioner happens to be an expert in the area. So the woman who argued Zarda for us and was a woman, Pamela Carlin from Stanford Law School. She had clerked for the Supreme Court. She's argued there before. The other lawyer who argued on behalf of the two other plaintiffs, or the transgender plaintiff, was David Cole from the ACLU. These people really know what they're doing. The temptation, if your case reaches the Supreme Court, is that if you argue it yourself and you win, then you can brag about it for the rest of your life. You know, I argued in the Supreme Court and I won and I'm great. But if you get knocked around during oral argument and the justices get the best of you, then it could be a very humiliating half hour, because when you're arguing in the Supreme Court, you have 9 judges who are throwing questions at you in non sequiturs, and you'd better have a good answer, or else it's going to be, it'll be pretty uncomfortable. And it might even be written up in the New York Times, local lawyer gets knocked around in the Supreme Court because he gave a bad answer. So what people tend to do these days is they tend to farm out the argument to somebody who's been there, who knows what you're doing, knows what they're doing, and you owe it to your client to have the best possible person to argue it. So anyway, it gets argued October 8th, 2019. We all show up in Washington. This is before the pandemic, so we took the train, we took the plane, and we show up at the court, and this was the big issue at the Supreme Court at the time. Nobody knew that the court was going to take up the tax return subpoena cases from Trump. The Bostock Zarda case was the case of the year. And you show up the morning at the court, and there's protests outside the Supreme Court building. The Supreme Court has a huge concourse, this huge concrete concourse, and then there's a street in front of it that's closed off, and there must have been just hundreds of people running around, yelling, carrying signs. It wasn't chaos, but there was a lot of people from around the country, most of whom were on our side, which was nice to see. And that's what the case means for people. Some people, well, the courtroom is very small at the Supreme Court. It only fits 250 people. So if you want to see a Supreme Court argument, you don't get a ticket in advance. There's no lottery or something like you get concert tickets. You have to show up and get online. And for a big case, you may have to show up 2 or 3 days in advance. And so you'll have people sleeping on the sidewalks in a suit and tie because they want to see the oral argument, which is crazy. And, just a brief editorial comment, this has to change. They have to stop doing this to people. There has to be a better way, maybe a lottery system, because you show up and there are people who have spent 3-4 days on the sidewalk sleeping and living, and, it's pretty bad. And you're not guaranteed an opportunity to see the arguments because they only fit 250, and that gets filled up pretty quickly on a big day like oral argument day in our case. So while the Supreme Court building is huge, the courtroom, the only courtroom in the building, is actually pretty small. And they call the Supreme Court the Marble Palace because it is all marble. It is a beautiful place. No matter what your views are on the Supreme Court and what they do, and whether you like some of the people on the court or whether you don't like people on the court, there really is a sense of awe when you walk in, because it's a very quiet place. They don't really allow people to talk loudly. It's marble everywhere, oil paintings of old justices everywhere. It's really like a museum that happens to have a courtroom, on the 3rd or 4th floor. And they escort you up a marble staircase to the courtroom. It felt like there were 200 steps. It was such a long staircase to the courtroom. I actually got dizzy walking up, and I had to stop for a minute and then continue. There are protocols at the Supreme Court that are strictly enforced. They give you your seats. We had assigned seats in advance because we worked on the case. No cell phones. You can't bring a newspaper. You can't bring a book. All you can bring into the courtroom is a notepad and a pen. That is it. So I was sitting there talking to somebody next to me, and my reading glasses were on my head. And one of the marshals, one of the people who works for the court, pointed at my glasses, which signified that I had to take them off my head. They're very serious, that you pay attention and that you listen, and they don't want people whispering and reading and looking at their phones and doing what we do in the world. It's the Supreme Court, and they're very serious about people listening to what they're doing, because they really do want to be above the fray, even if you think they're not in the way they make decisions. Their public image is very important to them. So eventually you watch the argument. This was a 2-hour argument, which is normally it's 1 hour, but since there were 3 cases, they devote 2 hours to the argument. And I must say, probably the most intense 2 hours of my life. Because when you're watching an oral argument in any court, you're really listening to what the judges are asking, because you think it might shed light on what the judges are thinking. And when you're watching a Supreme Court argument, every single question from any justice generates a million questions in your own head that take off immediately. You know, who's asking the question? What is she asking? What do they mean by this? Does this mean we have his vote? Does this mean we don't have his vote? What's going to happen? I don't know. All of that goes through your head before the lawyer can even answer the question, because the judges try to be cagey. They try to be discreet about where they're going on a legal issue. So you end up reading tea leaves into it. And then afterward, of course, you talk about what this justice asked, what that justice asked, but you don't really know where they're coming down. The only justice on the Supreme Court who really told us how he was going to rule on this case was Justice Alito, who ended up voting against us. He told our side, basically, I don't see it, I don't see it. So we didn't have Alito. But we didn't really know much about the others, and we figured we had the 4 Democratic appointees: Ruth Bader Ginsburg, Sonia Sotomayor, Alana Kagan, and Stephen Breyer, but we didn't know which of the 5 conservatives would be on our side if we were to win. We just didn't know. And I thought we were in decent shape when I was watching the argument. Justice Gorsuch, who I mentioned was appointed in 2017, he seemed, based on his questions, he seemed to understand our position. I thought he let slip a couple of comments suggesting he was on our side, but you don't really know. A lot of Supreme Court arguments involve hypotheticals, where the justices are sort of trying to get you to explain the consequences of any decision you want them to reach. If we rule for you now, what's going to happen in the next case? And what if these were the facts? And what if those were the facts? And this is where a specialist really comes in, because if you can't answer the hypotheticals, it's not enough to tell the judge, well, judge, you're asking me a hypothetical. I can't answer a question like that. They don't like that answer. They want you to answer the question, and you give it the best answer you can, even if you feel like your answer is going to hurt you. And for some reason, at the oral argument in this case, a good deal of the questions turned on issues surrounding transgender bathrooms and Title IX sports. And these issues were not even relevant in these cases. These were wrongful discharge cases having nothing to do with transgender bathrooms, certainly having nothing to do with Title IX sports. But the justices were trying to figure out where their ruling in our case might affect somebody's case 2 years from now, if somebody won't use the transgender bathroom or whatever. And that took up a good part of the oral argument. So those questions I thought were irrelevant to our issue and didn't really shed light on where the court might come down. But again, based on what I saw at the argument, I thought we were in decent shape. Gorsuch seemed to understand where we were coming from. Chief Justice John Roberts, who's pretty conservative, he didn't beat up our side, which is a pretty good sign, because if a judge really is against you, they'll signal that, and he didn't. Kavanaugh didn't really ask much in the way of questions. So, outside the court, when the argument ends, they escort us out of the building, and you go back outside onto the big concourse, where again, there's hundreds of people yelling and screaming, carrying signs, protesting. It was really something. But there was a celebratory mood post-argument that we thought we were in decent shape, simply because we thought we were still in the ball game. It doesn't mean we were convinced we were going to win, but we felt like it went as well as it could have. We felt like we weren't beaten up and that we had a fighting chance. So to use a baseball analogy, we felt like it was the 7th inning. and we were only losing by a 5-4 score. We can come back, and that was generally the sense afterward, as we talked to the press and we talked to some of the protesters and we talked amongst ourselves about what we observed. And anyway, took the court about 7 or 8 months to make a decision. That's a long time. We thought maybe we'd get something in the spring, but the pandemic seemed to slow things down. So June 15th, just so you know, there's a website that, there's a blog that's devoted to the Supreme Court. It's called SCOTUS blog. SCOTUS is short for Supreme Court of the United States. And they know when a decision is going to come down, but you don't know which decision is going to come down. But a decision day for these people is Christmas morning. Something's going to happen, but you don't know what. And we figured it could very well be our case because we were nearing the end of the term and they can't put it off forever. The Supreme Court has a deadline. They don't do anything after June 30th or early July. They don't hold things over the summer. So we knew it was coming. And sure enough, we won 6-3. And that was pretty exciting because none of us thought we would get 6 votes. We thought at best we would get 5 votes, 5-4, but we got 6-3 ruling. And the justices on our side were the 4 liberals, Ruth Bader Ginsburg, Elena Kagan, Stephen Breyer, Sonia Sotomayor. Neil Gorsuch wrote the opinion, and John Roberts was also in the majority, which was a surprise, but that's what he did. The dissenting justices were Clarence Thomas, Samuel Alito, and Brett Kavanaugh. And the court did 2 things. Quote, an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. So the court continues, sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. And that's a pretty succinct way of putting the issue. It's probably better than the way anybody else had formulated it during the briefing period of this case. And that was written by Justice Neil Gorsuch. And his style as a Supreme Court justice, I think he's a very casual writer. He's trying to sort of loosen up the way that people write court decisions. And he wrote it in a way that everyday people could understand it because he knew this was going to be a big case. So he agreed with us that when you fire somebody because of their sex orientation, you're necessarily taking their gender into account. He also said, while Congress did not contemplate sex orientation or transgender discrimination in passing the 1964 Civil Rights Act, we interpret statutes by taking the statutory language as we find it. It is not so much what Congress intended when they wrote the law. Instead, we look to the language of the statute to see if it covers a new situation. So for legal eagles, people who think about these issues above and beyond the main issue raised in the case, this is a very important decision in terms of how a court should interpret a federal statute. You look at the language of the statute and you worry less about what people intended when they passed it. If the statute covers your situation, then you're protected under the statute. And there's precedent for that with the sex harassment cases. That wasn't even mentioned in Title VII from 1964, and everybody now regards it as a form of gender discrimination. So that's what the Supreme Court did. I mentioned earlier there was always an effort by people to have the statute amended for Congress to amend Title VII to include sex orientation. Those efforts are gone. There's no reason to do that anymore. The Supreme Court did it for us. And that's rare, but that's what they did. What does the future hold in this area? This interpretation of gender discrimination probably applies in non-employment cases also, including discrimination in schools, discrimination in public accommodation. There are many statutes that prohibit gender discrimination and say nothing about sex orientation discrimination. My assumption is that the Bostock ruling means that all the statutes that prohibit gender discrimination now prohibit discrimination on the basis of sex orientation and transgender. There are probably going to be cases over the next few years involving religious objections to hiring gays, lesbians, and transgender employees. That's probably next on the list. Sure, somewhere somebody's filing a lawsuit as we speak, making that issue that you can't force me to hire somebody who's gay because my religion opposes it. The Supreme Court happens to be very receptive to these arguments in other contexts. We see it in birth control and employer and government mandated health insurance and whether an employer is allowed to opt out when it comes to subsidizing somebody's birth control because it's against their religion. And a couple of weeks ago, I think a week after the Supreme Court issued Bostock, they credited such an argument. And they said that the Affordable Care Act cannot require an employer to pay into health insurance if the proportions of that health insurance, including birth control, violate the employer's religious principles. So my feeling is that's going to be next on the agenda in the area of employment discrimination and sex orientation. That's just my best guess. As for the parties in this case, their cases are not over. All the Supreme Court said in these three cases, Bostock, Zarda, and Stevens was the transgender case. All this decision means is that their cases are now allowed to go to trial. And they still have to prove that they were discriminated against based on their sex orientation or transgender. They could theoretically lose if the jury thinks they were fired for some other reason, or they were bad employees, or the employer meant well, or all the reasons you can lose a case. That's ultimately what it means for these three plaintiffs. So technically, they have not won their cases yet. They won on a major legal issue, but they have not won their cases yet. But this decision certainly allows a lot of other people to bring lawsuits if they think they were fired based on their sex orientation or transgender status. So that's the issue. That's what's going on in this case. This is sort of a landmark ruling by the court. Many people were not optimistic that we would win because they assumed that with 5 conservative justices, we would lose. And sometimes the Supreme Court surprises you, and this is one of those cases. All right, June, do we have any questions?
I was riveted. I believe everyone was riveted. And so what that means is no one had a moment to type in a question. I think that's a good sign. That was amazing. I'm so thrilled. Thank you, Steve, so much. People may have questions now, however. I know I have a couple that I put together earlier, but let's see if anyone else wants to unmute themselves and go first.
I have a question.
Yeah.
Thank you, Stephen. That was really great. A lot of information. So is it accurate to say that in this ruling, the Supreme Court makes no judgment about the merits of those cases? It's just a legal argument, or
Exactly.
Is there some? Okay.
Exactly. They never said Zarda deserves to win. They never said Bostock deserves to win. They didn't even spend much time in the opinion actually talking about the facts of their cases. All they said was each of the plaintiffs in these cases claims he or she was fired because of their sex orientation or transgender, and then they moved right on to the legal issue. Yeah.
Okay. Is that typical for these kind of cases?
Yes. Yeah. They only decide legal questions. If you go to the Supreme Court because you think you simply have a better case, I have better evidence than the other guy, I should have won my trial. The court will almost never take that case unless it raises some really unique legal issue. But they probably won't, because that's not their job. It's a different kind of court than the court that we're normally used to, that actually decides who wins and who loses.
Steve, I have a question. Thank you. I think you did a very careful, thorough job. I've tried to explain some of that stuff in broader context, and you did a beautiful job. It was very articulate, very clear. I'd love to hear you talk a little bit about what you went through in preparing the brief and choosing which arguments to make and which arguments not to make in the brief that you filed with the Supreme Court.
Yeah, the brief was a team effort. And so when we hired the Stanford law professor, Pamela Carlin, she sort of took the lead because she had been there before. And, we all contributed. We had strategy discussions on the phone. We threw around ideas, and we eventually settled on the one issue that was the winning issue, when we abandoned the issues that we had prevailed on previously. And that surprised me, because had I been the one in charge, it never would have occurred to me to abandon an argument that had prevailed in a lower court. And the thinking was, you know, and this is true whenever you're in an appellate court, go with your best argument. Go with your best argument. If you can't win on your best argument, then you can't win. And I'll give you just a sense of one of the concerns. For example, the associational discrimination angle, which I mentioned earlier, you know, that won in the Court of Appeals. The problem with that argument is the Supreme Court could say, okay, you know, somebody can win their case if they're fired for associating with somebody of the same sex, but your client, you know, was not in a relationship at the time. So your client can't win. And that's a fair point, you know, and that means that not everybody wins under a decision like this. The way the Supreme Court wrote up the opinion, you know, that you're taking gender into account every time you make a decision based on sex orientation, that's what we call a bright line rule. You know, everybody has a chance to win under that formulation of the statute. It doesn't matter if you're in a relationship or not. It doesn't matter if there's stereotyping. It doesn't matter. So in a sense, this has the same effect as if Congress had amended the statute itself. That was a nice surprise. That occurred to me when I was reading the opinion. This decision, you know, there's no gray area here. You know, if you're fired and you can prove that you were fired because of your sex orientation, you will win the case. And there's no ifs, ands, or buts. So it was interesting how they do that. They don't always do that. Very often the Supreme Court has a ruling and then they drop a footnote and says, well, you know, in certain instances, A, B, and C. And then you worry about A, B, and C for the next 4 years because you could lose because of A, B, and C. That didn't happen here.
Thank
I
you.
think Irene, did you have a question?
I did. Do you think that employer, it was wonderful. Your talk was wonderful, and it really, I
Thanks.
didn't realize that this didn't automatically mean that these three different individuals are going to win their case. But do you think employers of a certain ilk will simply work around it as much as they can? I mean, strategize.
They do anyway.
Strategize, say, about their evaluations and about this and about that.
Yeah, they do that anyway, because if you bring an employment discrimination case, very rarely can you, there's never a smoking gun. So, you know, it's never the case that somebody is on tape or puts it on writing, you're fired because you're a woman. That doesn't really happen. The way it happens is you have to prove it circumstantially. So, you know, they say, well, you're fired because you come in late all the time. And you're like, wait a minute, you know, everybody comes in late. Why are you singling me out? I'm the only woman who's being fired for this. That's how you prove it. So if an employer wants to strategize around this decision, it's no different from the strategies that they've been doing for the last 50 years, you know, coming up with a reason, and then your job, since you bring the lawsuit, is to prove the reason is not really true. And the real reason is race, gender, sex orientation. And then it becomes a battle. And then you spend 2 years, you know, taking depositions, reviewing documents, going to court, maybe you have a trial, and the trial is for this really the sole purpose of determining whether the employer's strategy is going to succeed or not. Because no one ever admits to firing somebody because of their gender or race or religion. I mean, it would be crazy to do that. You're asking for a lawsuit. Anyone else?
Yeah, I have a question. Hi, my name is Giordana. Thank you so much. You talked about the Title VII does not discriminate in the workplace based on gender, but it's actually sex in the words they used, correct? Can you clarify something for me?
Yeah, they use the word sex, but it's been interpreted to mean gender, you know.
So according to the Supreme Court, there is no distinction, because in my field, which is psychology, there is a huge difference between the two, right? And but the Supreme Court did not take into consideration this difference.
No, they treat sex and gender as having the same meaning. You know, that you're firing somebody because he's a man, you're firing somebody because she's a woman. that's the way they see it. I don't think they've ever really explored that issue. I know there's psychology literature on that issue, but it's never come up in a Supreme Court case.
Huh. Okay, thank you. And can you tell a little bit more, because I remember that as well, that during the oral arguments there was something that Gorsuch was saying that thought, maybe it's on our side.
Yeah, that was it. And
Indeed.
and I forget what he said, but he was debating the issue with
Hagan.
No, he was with the lawyer for the employer.
Okay.
And our side had already sat down, and the attorney for the employer got up and made his pitch. It was somebody from the Solicitor General's office, which is a federal office that all they do is argue in the Supreme Court on behalf of the administration. So somebody from the Trump administration, I think Noel Francisco, his name is, he's arguing the issue, and Gorsuch made some comment like, doesn't it seem logical that if you're firing somebody because he's gay, you wouldn't have done it if he was a man or something? And when he said that, I said, oh, all right, maybe we got him. And that's what you're thinking when you're watching argument. Your brain is going a million times a second, and you've overanalyzed every question, even before the attorney has a chance to answer it, because it's so intense and you're reading tea leaves. You shouldn't do it, but we all do it because that's why you're there. Otherwise, you'd wait to read about the argument in the newspaper the next day. This is why people sleep on the sidewalk for 3 days to see the argument, because they don't want to wait till the evening news. They want to see it themselves. It's almost like it's theater. It really is like theater. In fact, it's set up like a theater. There's beautiful curtains behind the justices, and they all come out at once, and it's this beautiful place. It's like going to the theater. It's part entertainment, except you can't clap or do anything. You can only watch and just really pay attention, because you really don't know what to expect when you're walking into the room.
Thank you.
Steve, this is Paul. Oh, hi. This is Paul. I had a quick question for you. There were 3 cases here, and what brought the cases together, and how did you, as 3 separate teams of lawyers, come together? I mean, the working dynamics here, it seemed like each of the cases was slightly different. So how did you bring yourself together on that?
It was the same legal issue. So they all came to the Supreme Court at the same time. When we won Zarda in February 2018, the Bostock decision came down maybe a couple of weeks later from the 11th Circuit, which is down south. And Bostock lost. So we knew it, that, there was probably going to, and that it was probably going to go to the Supreme Court, because the losing side in Zarda filed a petition to the Supreme Court. And then the losing side in Bostock did the same thing. And then Stevens, the transgender case. And when that happens, you can be pretty sure the court might take the case. Plus, it's an important issue. I mean, everybody knows this issue's been percolating through the courts for a while. So we thought there was a good chance. And the court decided on its own to consolidate all 3, because the legal questions were so closely related to each other that it was just more efficient to have everything as sort of one super case than 3 separate cases. So the court decides to consolidate.
Okay. All right. And you, as teams of lawyers, somehow came together and
phone conferences. We had phone conferences to talk about what we were going to do, how we're going to do it, and then they start writing the brief, and the brief gets circulated around. Everybody gets emailed a copy, and you have 3 days to make comments, and you send them back, and then we talk about the comments and whether they're good, whether they're not good, and there's disagreement. People don't always disagree on strategy, right? But there was. You do have deference to the attorney who's going to argue it, who's argued there before and has won before, because the assumption is she knows better than we do. I mean, I do a lot of appellate work too, but I've never been to the Supreme Court, so I'm not going to be the one to tell somebody that my way is the best way. And the risk is, when you have a team working on the same case of a bunch of lawyers, too many cooks can spoil the pot. And,
yes.
And there is a value in somebody, stepping back, trusting that your teammates are good and they know what they're doing, because you don't want to, make things worse. I mean, you are working on deadline here. It's the way any organization has to make decisions. You're working on deadline, and you don't want to cause problems by insisting that you're right and somebody else is wrong. I really gave a lot of deference to the attorney, Pam Carlin, on her judgment on this.
Very good. Thank you.
Hey, Steve.
Yeah.
Bob Miller. Great talk. What you weren't on the case originally, I take it. You were brought on when it went to the appeals level.
Right.
How did that happen? Did they just call you up and say, "Hey, come on, join the team"? Or
Yeah,
what?
I knew him. He was a sole practitioner. It's going up to the Court of Appeals on this major issue. I had worked with him before, and he asked me, I have this great issue. It's going to the Court of Appeals. I said, sure. When you're a lawyer, you want to work on interesting cases. And, sure, count me in. I'll join the case. It's really as simple as that. It's a pro bono effort primarily. You don't know if you're going to win, but you do it because that's why you become a lawyer, to work on cases like this, really.
Thanks.
I don't want to take up someone else's time if they have another question, but you raised the issue, Steve, of how broadly this employment discrimination
I'm seeing
issue
Fred
might
trying
be
to get
applied
in.
in other settings. And one of the settings for LGBTQ plus people is not just employment discrimination, but in housing and in mortgages and banking and other stuff. How much of this do you think will extend into the issue of housing situations for people?
I would say probably, because the housing discrimination law reads like the employment discrimination law. The employment discrimination law really is the template for all subsequent discrimination laws. And the others also say you can't deny somebody housing based on sex or gender. My assumption is that those laws now, based on this case, prohibit discrimination based on sex orientation or transgender. That's my assumption. I suppose somebody's going to argue that it doesn't, that there's a reason to distinguish housing from employment. I don't know what those arguments might be. But there's always a legal argument for a particular there's always a legal argument somewhere for somebody. And then it goes back to the Supreme Court in 5 years to deal with that question, because they can't deal with all the questions. They're not going to give an opinion about how this ruling affects other statutes, because that's a hypothetical and they don't really do hypotheticals. So when they got bogged down on, bathrooms, like I knew that wouldn't affect the outcome of the case, because they don't decide cases based on hypotheticals. They worry about that next time, in 2022, that case will come before the Supreme Court. And they don't worry about that today. So this is not really the last word on sex orientation discrimination, although it's a pretty strong first word.
And it opens the door for that whole highway of stuff to happen.
Oh,
From
yeah.
your lips to God's ears. Thank you.
Well, and was there
Stephen?
another, oh, sorry. Tom, you want to go ahead?
Yeah, Stephen, I know that you said that the judgment of the Supreme Court here was so clear that in a matter of law, that it was going to cover additional areas, perhaps like housing. But I find it hard to believe that there won't be additional legislation that will be required in the near future. Do you have an opinion about what are the most pressing areas that would require additional legislation to extend the rights of gay and other people who were affected by this ruling?
Congress could amend all the other statutes anyway, just to make it clear. Like Congress could say, all right, just to be sure, the Fair Housing Act of 1968 now prohibits sex orientation discrimination so that there's no room for contrary argument. That could happen. A lot of it depends on who gets elected in November, I suppose, and what the Senate looks like. I mean, there's always room to amend the statute the way you want to, I'm not sure how much further you can go, except maybe to codify it by law, so that a future Supreme Court 50 years from now doesn't come out the other way, although I doubt that's going to happen. I mean, there hasn't been much in the way of like marriage statutes in the wake of the same-sex marriage law decision 5 years ago. So I guess nobody thought of a way to rein that decision in or to expand it any further. So my guess is nothing may happen on this. We just accept it as a fact of life. And then you just take it for granted that you can't fire somebody or discriminate against somebody in any context based on sex orientation or transgender.
Thank you.
Does
I have a
that include the context, sorry, of religious schools? Was there a decision that religious schools are protected from discrimination suits?
Yeah, there was a case like last week or 2 weeks ago that said that certain employees of religious schools are not protected under Title VII at all, because religious schools have the leeway under the freedom of religion clauses of the First Amendment to decide who they want to work for them. And that's coming close to a bright line rule also. So no matter what happens to you, if you're, what it seems like they said is if you're a teacher working with kids and, you know, part of your job is to teach religion, because that's what you do when you're teaching in a religious school, in addition to math and science, is that since they have the right to decide who's going to teach their kids, it's an intrusion. It's an illegal intrusion by the courts to tell religious employers or religious schools who can work for them, and they can fire people as they see fit, because no matter what the reason. So that's one way around this. You know, like I said, the religious exception to this ruling is lurking somewhere. And, you know, when you have a case in the Supreme Court, you have what we call amicus briefs. And so you have a lot of people submitting legal arguments who are not parties to the case. And there must have been dozens that were filed in this case. I still have them in a box up in my office. And, you know, a lot of them were filed by religious organizations who said, you know, you can't expand the law the way Zarda and Bostock and Stevens want you to expand the law, because it's going to interfere with our religious principles, you know, potentially to have people working for us and, you know, we don't approve of their lifestyle. I mean, that argument exists. And again, the court didn't address it, but those arguments are waiting to be heard by a future case. You can't predict what the future is going to bring. If you have, if Joe Biden is elected in November and he appoints 3 or 4 people to the court, you know, none of these issues may happen, because, you know, the votes aren't going to be there to rein in the scope of Bostock. And any justice appointed by Biden will probably agree with what the court did and not want to scale it back. That's my sense. But you can't predict what a future court is going to do.
I have a question. What did the court not leave and say, we're not dealing with it right now for this?
Well, nothing in particular. They didn't explicitly say, you know, sometimes they do this. Sometimes they drop a footnote and they say, we leave for another day, you know, the issue of X, Y, and Z. It's not before us and we'll decide it, you know, some other day. It may be in here. Just so you know, this is what the case looks like. If you can see it on the camera, this is double-sided. This is a 160-page decision by the court. It took me a week to read it. So there may be something buried in the opinion that says, you know, we'll deal with other issues that as they come to us. But that's common for the court. They don't want to go out on a limb if it's not precisely the question before the court. They have the luxury of waiting 3 years to take it up if they want to.
So sorry, I wasn't clear. I didn't mean this case. I mean, what did they leave any other cases and say we're not dealing with them this term? That
Oh, in other cases, you mean?
Yeah.
Probably.
In other words, did they leave any cases that probably people that are happy about this decision might be worried about?
Well, yeah, the tax subpoena cases, actually. I think the case that came before the court about Congress wanting Trump's tax returns, they didn't say Congress gets those tax returns, you know, 9 a.m. tomorrow. They said, okay, if you want those tax returns and you're a member of Congress and you're investigating, you know, the president, you have to satisfy these criteria. And the court came up with this 5-part test, which courts love to do, and said, this is for the lower courts to worry about. And, everybody has to get back to the lower courts and basically start over because we have just changed the rules on when Congress can get tax returns. So people were happy that Congress, can get the tax returns, but it's potentially getting the tax returns. They didn't say they're actually getting them. They said this issue, what they're doing is they kept the issue alive, and it may go on another year, who knows, right? But that's common with the Supreme Court. They like to sometimes be minimalist and resolve a very narrow question and then send it back to the lower courts for them to worry about.
Steve, I did see to that question that maybe they're going to take up a court case next fall about the suitability of same-sex parents to provide foster care. Do you know that it was a Catholic Charity v. Philadelphia or something?
I thought I saw something on that.
I know you can't predict, but what would you predict might happen in that case?
Who knows? That's my answer. That's something they never took up. They never take up adoption cases. So, they probably think, we're not family court, take it to family court. They can be very parochial on that, but I don't know what they would do. A lot of it depends on who's on the court in a year. My guess, I don't want to get too political on this, but, if Biden wins, maybe Ginsburg will, retire and say, I'm done, replace me with somebody, younger. And then that changes the court. I don't know. These are issues that the court probably, when a justice gets on the Supreme Court, these are issues they never thought they'd have to worry about. Seriously, they just never anticipated that they would take up a tax return subpoena case, right, when they joined the court. And here they are having 2 in 1 day last week. So, I don't know. I don't know what they would do with an adoption case, same-sex adoption.
Or it was foster care, I think.
Foster care, I don't know.
Yeah.
Who knows?
Any other questions? We've kept Steve, and I can't tell you how thrilling this was, Steve.
I have
yes,
one more
applause.
question.
You have
I
one
have
more?
one question.
Go ahead.
It's a gossipy question.
Yeah.
How about Kavanaugh and Clarence? How did they sound?
Well, Clarence Thomas doesn't really ask questions at the Supreme Court. He's explained that he doesn't, the others ask enough questions where you don't even notice that he's not asking questions. His theory is there's too much questioning from the judges and you don't let the lawyers speak. And he wants to hear the lawyers. And, the more cynical angle is, well, he's already made his mind up. He doesn't need to hear from the lawyers. But there is something to the point that too many questions can really make for an argument that's impossible to follow. I've argued a lot of cases. And when you start being hit with non sequiturs, one after the other, you could be thrown off and the argument can sort of take a detour into some place where nobody even cares about it anymore. So Thomas didn't ask any questions. Kavanaugh only asked maybe 1 or 2 questions that didn't seem, that they really seemed peripheral to the issue. And he didn't tip his cap. Some of the justices make no bones about where they stand on an issue, but Kavanaugh didn't do anything that told us one way or the other. We really had no idea. There was some sense because he's younger that maybe he's more sympathetic because, the younger you are, the more sympathetic you might be. But that didn't turn out to be the case. He actually dissented. But Gorsuch, who's also about the same age, he wrote the opinion. You remember that anecdote I gave about Justice Powell talking to a gay clerk and he didn't even know his clerk was gay. That's not the case anymore. Everybody on the court knows people who are gay. It's a different world. I think it makes it much easier for the court to accept its ruling when they know people who are gay. This is not the 1970s where, people kept quiet about these things.
Stephen, I have one more question. You said that the 3 plaintiffs didn't win their case, they won a legal argument. Mm-hmm. So they have to go to trials, but 2 of them, Stevens and the one you represented, actually died.
Yeah.
So can their relatives bring their case to trial? So
their family can carry on and, it's difficult to win a trial when your plaintiff is deceased.
Yeah.
because the jury doesn't get to see them, and the jury can't relate to them, and the jury doesn't get to know who they are. You know, what you have to do is read their transcript, their deposition transcript to the jury. And needless to say, that is a far cry from having a real person sitting in the witness box, looking at the jury, telling them, you know, I was fired, I did the best I could, I can't believe it, my life is ruined. That's very different from having, you know, black and white transcript being read to the jury. What you have to do is find somebody with a personality who's sitting in the witness box and answering the questions so that you can do it in a way that holds the jury's attention. But that's difficult. You know, maybe the cases will settle, you know, now that, you know, you've come this far and everybody's beating each other up. You know, all these cases are at least 5 years old. So very often, once this happens, the cases tend to settle.
Thank you so much.
Yeah.
Well, June and Jason and Bob, I want to thank you for letting me know about this stuff. I shared it with members of the LGBTQ Center in Kingston. And if there's any chance of getting a recording, I will also spread that out, because this is a major issue for anyone in my group, that it's huge life and death for so many people all across this country. And hearing you talk about it in such an articulate way, Stephen, is wonderful.
Thanks.
And I'd love to share it with the men's discussion group and the women's discussion group and board of the center. And so if that's possible, June, and thank you for letting me know about it.
Yeah, absolutely. I want to share it with my daughter, who wants to go to law school eventually. Should definitely be required viewing.
Yep.
Wonderful. All right, Steve, thank you so much. Thank you everyone for joining us. And yes,
Thanks,
there will be, the recording will be linked. We will share with you where that is, where you can find it when it's up and available.
Thank you.
So and that'll be thanks to Paul Edlin. So
Thank you so much.
Thank you, Paula.
Yay.
Thanks, everyone.
Thanks, Elting.
Thank you.
Stephen.
Have a wonderful night,
Okay.
everyone.
Bye,
Thank you.
everyone.
Bye-bye.
Bye.